a discussion with the chair of the the independent chair of the Safeguarding Children's Partnership. Following that discussion and further discussions with the director, the executive member and the chief executive of the council and others, I felt it was appropriate to bring this item to the board today. You've received a late paper around notification of serious incidents review. In order to understand the context and set the framework, I've asked Rebecca Roberts to come to the board, and Rebecca will introduce herself and her role. And what I'm hoping Rebecca will just talk us through is what the notification process is, what the recent changes are around that, and also to explain to the board what the members of the partnership have to consider when they're looking at a particular case, so that we can understand all of those things. So if I can hand over to Rebecca to introduce herself first and just talk us through those things.
Thank you very much, Councillor. Yes, my name is Rebecca Roberts. I'm a legal officer with the Leeds City Council, and I'm also the legal advisor to the Leeds Children's Safeguarding Partnership. Hopefully, members have already had the opportunity to read the report in anticipation of this morning's meeting. And in accordance with what Councillor Lamb has just said, I hope to be able to just flesh out a little bit more information about the legal framework that is referred to in that document. As mentioned in the report, Sir Alan Wood undertook a review of local safeguarding boards and their arrangements back in 2015, and that review was published in 2016 and made various recommendations for what in effect would hopefully make local safeguarding children's boards more effective. And with the review came legislative changes to the Children Act 2004, which was the previous piece of legislation that introduced safeguarding boards. That act was amended by the Children and Social Work Act in 2017 and introduced a new framework to support the delivery of multi-agency services to protect and safeguard children. The legislation abolished the children's safeguarding boards and introduced the new concept of safeguarding partners and involving local government, the police and health services. Previous legislation had provided for local safeguarding boards to undertake serious case reviews where appropriate, and that was a decision that was collectively taken by the board, and no doubt that is a term that members of this committee will be more familiar with. The new arrangements for all areas across the country were to be in place and published by September 2019. Some areas, some local authorities were early adopters, and their arrangements had been in place since the summer of 2018. Leeds introduced their new arrangements in September 2019 and welcomed their new chair, Jasvinda Sangira, who is here with us today by December, or rather we welcomed her in December 2019. Along with the new legislation came a new safeguarding practice review panel. That is a central panel established by the Secretary of State and more commonly referred to as the National Panel. And the legislation also introduced a new framework for reporting serious incidents to this panel, also more commonly referred to as notifications, and a new framework that would sit behind those notifications around the assimilation of learning as a result of any notifications that were made to the National Panel. The reporting of these incidents is one of the new responsibilities under the Act, which places the duty on local authorities in accordance with Section 16 of the Children Act. And the local authority, where it knows or suspects a child has been abused or neglected, must notify the National Panel if that child has died or has been seriously harmed. Either the child is in its area, or if normally resident in its area, it either dies or is seriously harmed somewhere outside England. This notification must be made within 5 days of the date of incident. The notification is made by the local authority. It is then incumbent upon them to inform its partners within the partnership, and as a result of that notification, what is called a rapid review is undertaken. The rapid review involves assimilating all that information from partners and other members of the wider partnership who may or may not have had specific involvement with the family. And that review should take place within 15 days of the notification and provide as much learning as possible to the partnership. Partners are then tasked with the job of deciding whether or not the learning that they have gathered within the course of that 15-day rapid review is sufficient to implement any learning, or whether further learning is required, perhaps in the context of what is called a child safeguarding practice review. And the criteria for the partners to apply when considering this next step is also set out in the Children Act. And there is quite a long list of criteria that the partners must consider when they are deciding whether or not to commission a child safeguarding practice review. And it may well be that they do commission a local child safeguarding practice review, but they also have to consider whether or not they should refer to national panel the need for a national review to take place, one which may involve themes that could affect other local authorities and there be of national importance. And no doubt this committee will be aware that such a review has been commissioned in relation to the deaths of Star and Arthur last year. So that's an ongoing piece of work that the national panel is undertaking. So the new arrangements have been in place in Leeds since September 2019. And since then, there have been 6 notifications involving suspected abuse or neglect, and 1 notification which did not. Currently, the LSCP is undertaking 3 of those child safeguarding practice reviews that I just previously mentioned, including 1 review where no notification was made. And the review and advisory subgroup of the LSCP is also currently overseeing 10 other cases where the criteria for a notification was not deemed to have been met, but learning could still be gathered. Sir Alan Wood has reviewed the implementation of the new multi-agency arrangements in May of last year, and he noted that resources for protecting children are under much stress, and the recruitment and retention of safeguarding professionals remains a challenge across the 3 statutory agencies. If there is anything else I can assist the committee with at this moment or later.
Yes, please, Rebecca, it'd be really helpful if you could just talk the board through what the partners have to consider when they are looking at one of these cases and deciding whether or not to make a notification.
Gladly. Thank you, Councillor, and apologies for having swiftly glossed over that particular part of the process and the collective consideration that the partners must consider at that point once the notification has been made and the rapid review has taken place. So the criteria which the local safeguarding partners must take into account include whether the case highlights or may highlight improvements needed to safeguard and promote the welfare of children, including where those improvements have been previously identified, It highlights or may highlight recurrent themes in the safeguarding and promotion of the welfare of children. It highlights or may highlight concerns regarding 2 or more organisations or agencies working together effectively to safeguard and promote the welfare of children, and is one which the Child Safeguarding Practice Review Panel have considered and concluded a local review may be more appropriate.
Okay, thank you. That's very helpful. So I just want to check at this point if anyone's got any specific questions about what they've heard from Rebecca before we go into that. So I've got Councillor Stevenson and Councillor Lay.
Thank you, Chair. There was quite a lot of information there. Thank you. But for us sitting here, it's quite a lot to take in. Could you just repeat for the board, please? I think you said it was section 16C of the Children's Act, the bit that sets out when the referral to the Children's Safeguarding Panel should be made. Could you read that again, please?
Yes, I beg your pardon, Councillor. An awful lot of information has been provided to the committee this morning. But yes, when the local authority whose duty it is to consider whether or not a notification should be made, that's in accordance with 16C of the Children Act 2004, and where it knows or suspects a child has been abused or neglected, it must notify the national panel if the child has died or is seriously harmed. And that also includes children who might have died or been harmed in another jurisdiction.
And does legislation give any guidance around what serious harm is?
Yes, it does, Councillor. That definition of serious harm is also contained within the 2004 Act, also within section C, and is about, as I'm going to quote it to you, if I may. And my apologies, Councillor, my fingers are not as fast as I would have liked them to be today.
Shall I take Councillor Lay's question while you're finding that, Rebecca?
Yes, please.
Yeah.
I'm grateful, Councillor Lamb.
Thank you, Chair. Ryan asked the same questions I was going to ask. Just one other note of clarification. Can I just be clear in my mind, when you said 6 notifications, you meant 6 notifications by this local authority to the review board?
Yes, Councillor, that's correct.
Okay. Have you managed to find the bit that we're looking for? Or shall I come back to you in? No problem. Okay, well, if you could let me know when we've got it, and we'll come back to that so we can keep going. So I'm going to ask Jasvinder to come in next, and just to set the context, my understanding is, and I think it's the first time Jasvinder's been to our board, so you're very welcome, and it's good to have you with us today. My understanding is that Jasvinder raised concerns about the process around notification in the authority in, I think perhaps sometime between February and September last year. My strong view is those concerns should have been brought to this board sooner. I've expressed that to the director and executive member already, and well, they will speak for themselves shortly. And I'm concerned that that didn't happen, but that's a separate issue. But so Jasvinder, if you could perhaps introduce yourself and then outline what you've come to say, please.
Thank you, Chair, and thank you for the invitation. I think I'll just start by introducing myself, and for people who maybe have tuned in that are lay people that don't know much about my role as well. As Rebecca said, I was appointed in 2019 as the Independent Safeguarding Chair. I'm accountable to the 3 statutory partners. My role is, I see it as ensuring that the multi-agency safeguarding arrangements do what they say they should be doing. They're effective and they're safe for our children, and that I represent partners, but also represent children. And part of my role is to ensure that I'm independent, I'm objective, and that where there is a need for challenge, that I do challenge. And within that role, the ability to ensure that we are representing the voice of children is key to everything that I do. So that's where I see my role. So the role of scrutiny, I take very seriously. With respect to this being here today, I actually raised concerns to be correct, in August last year, that I was not assured about the notification practice and systems across the city. I raised that on the basis that I chair the Review Advisory Group. The Review Advisory Group is made up of 3 partners, and Rebecca also attends as legal advisor. We have representatives from health, police, and social care, children's services there. So the Review Advisory Group deals with the most serious cases of vulnerable children, those of serious harm, those to be considered for notifications. And I was concerned that within the group, at times, partners will come to the table and share their concerns and give a view. And the word Rebecca used, I'd like to point out, is collective consideration. Albeit the local authority have the duty to notify a national panel, the importance of partnership is key here. And that is why we have multi-agency arrangements. We have to work in partnership to safeguard children and young people. So we will sit at that table. I will chair it. I'm not a decision maker in there. It's up to the partners to come up with the conclusions of whether something is to be considered a serious harm, taken in the definition. Within that definition, just to say that serious harm, we have to consider any long-term impairment on a child's mental health and their well-being, etc. I'm sure Rebecca will read that out in a little while. My concern was also highlighted to the point where I invited Annie Hudson, who chairs the national panel. So that is the national panel that sits within in government. And she did come to a meeting with many members of our safeguarding partners to have a conversation to talk about how we should be considering collectively what is serious as opposed to not serious harm. And within that space, we should all be applying our judgments within that space as well. And the point she also made in the meeting was, she made this point, to quote Annie Hudson, not me, that I as chair should consider why Leeds is an outlier compared to other cities with respect to notifications. That was her point made to me. So that made me come back and look at the systems more closely. And without going into case specifics right here, Chair, one case did concern me seriously. And on the basis of that, I did meet with, not meet as in Zoom meet, conversation with the Chief Executive of Leeds City Council. I also came to the exec and raised my concerns. And on the basis of that, there was an agreement to have a review into the notification systems, which we are having now, which I'm hoping should be completed by the end of March. So without getting into kind of what the practice issues are, I mean, that's my introduction. Thank you.
So thank you, Jasvinder. I think that's really helpful. So again, for the board's benefit, I'm concerned that all of this has been going on. A review is being undertaken. Serious concerns have been raised by the independent chair, and neither myself as the chair of the board or this board knew that any of this was going on, which I find unacceptable, but we will come to that shortly. My normal custom is to open questions to the board at this point. Because of the nature of some of the questions need to be asked, I'm going to ask them first on this occasion. And because there is a possibility, I'm going to refer to something which is in the public domain, but there is a potential that it could identify an individual. And so I'm going to propose to the board that to be able to ask the first two questions I want to ask of Jasvinder, that we resolve to exclude the press and public from the meeting and shut down the webcast and go into a private session so that we can ask the question and hear the answers, because I think it's really important for context for the board to do that. So I put that to the board, that we resolve to go into a private session. Everybody in agreement? Okay, so for the benefit of people watching at home, on the council's YouTube channel, I understand there are two meetings for this, part 1 and part 2. Part 1 is about to end, and in hopefully the shortest amount of time possible, part 2 will begin. So if I can ask for the webcast to be turned off, and I will have to ask, I'm afraid, any members